Hi folks, my name is Mike Foster and I'm an attorney who's been focused in estate planning for farmers for 41 years. My office is in Greensburg, Indiana, and I'm part of the team that has been working with GMO corn litigation. I am part of a legal team working on the Syngenta corn litigation that consists of Clayton Clark, a mass litigation expert from Houston. The next party is the chief litigator. That's Martin Phipps. He's an excellent GMO crop litigation expert from San Antonio. I have James Lee, who's a logistical expert from Houston, Texas. Next, we have Justin Demarath, who works with the different field attorneys in different states, such as myself. And then finally myself, Michael Foster, who is an Indiana-based farm legal practice and estate planning. While pursuing Syngenta litigation in the state of North Dakota, our team discovered that the government subsidy payments under the Ark County Payment Program are in error, and 43% of the North Dakota counties failed to receive full Ark County payments for corn production in 2014. The cause of the error is the 2014 Farm Bill, which was supposed to provide payment guarantee initiatives to farmers and in the form of ARC payments or PLC payments. This particular bill sets up subsidy payments for the farmer for 2014, 2015, 2016, 2017, and 2018 for a 5-year span. It requires that the farmer choose between the agricultural risk coverage known as ARC or the price loss coverage PLC programs that were newly enacted as part of the payment guarantee initiatives for farmers for various commodities, including corn. This farm bill requires farmers to choose between the PLC approach or the ARC approach, and the decision to choose is irrevocable. Most farmers opted for the ARC choice because they thought they would get better revenue. And ARC allows for consideration of the average yields for a farmer based upon a countywide basis or on an individual basis. And the determination of that is made from a number of different reports. If no election is made, the default election is for the PLC program, and that's going to persist for the 2015 through 2018 crop years. That election had to be made by March 31 of 2015, but no regulations were ever produced as far as how those particular standard payment were ever calculated. And the problem comes in calculating what the average price and yield should be in order to determine how bad the deviation has been to compensate the particular individual producer. The heart of the problem begins with the fact that the program is administered by the Farm Service Agency, or FSA, which is a part of the Department of Agriculture. But in doing their calculations, they use surveys from the National Agricultural Statistical Survey, or NASS, or your NASS surveys, in order to make the determination. NASS surveys are notoriously incorrect. They choose randomly who gets the survey. Not all farmers get the survey. When they do get the survey, over half of them will throw it away because it asks too much detailed information about their finances of farming. And when they do fill it out, usually it's because the survey agent is harassing them to give it back to them. So they tend to put inaccurate, low information into the survey, which results in a very low parity rate. That these reports are used to calculate the amount of payment is that a 5-year Olympic average is determined under the Ark County payments. The average year's yield in price for 5 years is computed from either the RMA, the market yearly, from the RMA reports of crop insurance, or from the NASS surveys, and the highest year and lowest year are thrown out. And the result is the market year average, or the MYA price. This is done for both price and for yield and combined, so the coverage is from 86% below a parity mark down to 76% of county revenue. With PLC, the reference price is in a statute and then does not change. It tends to be a higher parity rate, so there's a lower parity rate, so there's less money involved. The payment used to calculate the payments does not change, and the coverage is for prices below the reference price down to a loan rate. Most farmers have opted for the ARC County approach. The 2015 payments from FSA for these subsidies were expected to be nearly $4 billion nationally, but there has been a lot of disappointment. ARC County corn payments were expected to make the bulk of the ARC PLC payments. Despite a generally favorable 2014 crop, ARC County payments were expected to be large because the corn market average price was more than 30% below the benchmark price. But because of the mix of the NASS County data into this computation, and because of the fact that if less than 50% of the producers of the county turn in NASS surveys, the county is going to have a zero result. The result was that there were zero payments. Of the farmers that we talked to did not file their NASS survey, so probably 7 out of 8 failed to file it. The one that did file would have done so because they didn't want the survey agent coming around, so they'd put in data that was skewed very low. This was for the 2014 NASS survey. This slide shows the timeline that October 1 of 2014 is when the surveys were sent out, and you had to complete the surveys and return them. Nobody realized at that time, nobody had stated or given any kind of notice that it was going to affect the amount of subsidy payments that would be received for 2014. Later, in November 17 of 2014 to March 31 of 2015, that's how long you had to file the survey, and there was an election deadline at that time that the farmers had to make between ARC and PLC. In June of 2015 to September 30th, 2015 was a period for enrollment contracts in one program or the other. The result was that in many counties in Indiana, the amount of subsidies issued was $0 per acre. 40 counties in Indiana and 65 counties in Illinois were experiencing no compensation. And it's difficult to believe that in all the producers in those counties, nobody was qualified to get a subsidy payment. Many neighboring counties were seeing significant arbitrary and unfair differences in government underpayments. When our statistical experts started crunching the information, they found that there were a lot of underpayments in the counties that did receive those payments. And our point is that you could be next. Who will receive maximum ARC County payments? Those who receive those payments for 2014 may see either a minimal or zero payment in the subsequent 3 or 4 years of the program. These levels can last for the entire 4 years of the program.
The next slide shows a map of the state of Indiana, where 81% of the Indiana counties are not receiving a full ARC County payment for the 2014 corn crop. And the biggest problem here is the NASS surveys. You can see that an area basically between I-70 and I-64 are where most of these particular counties lie. The reason for these fluctuations is the methodology for calculating the benchmarks and the average yield, and we're contending that that's flawed. Some counties use data from the NASS surveys. Some counties would mix that data, and then other counties relied on risk management agency information only. These two government agencies use their own methods to determine yearly average yields, and NASS is not really a government agency. It's a private outsource to which the Department of Agriculture turns from time to time for surveys, but it does not carry any statement on it that incorrect information is being submitted under penalty of perjury. So there's no incentive for people to put down honest results. And as a result, it is a skewed source of statistical data.
Recorded in the NASS surveys greatly has skewed the critical data point in the benchmark formula. You must have sufficient participants returned the survey in order for this skew not to happen. They discovered in Lemoore County, North Dakota, that the NASS survey responses were 3 farmers short of the participants that were required, and 50% short of the production acres, and therefore the county received no compensation. This is probably what's going on in the 40 counties in the central part of Indiana. If not enough NASS surveys are returned, the RMA data serves as a default to figure the benchmark, and that runs 10 to 30 bushels higher than the NASS data, and the result is that the price yield mix is too high for the farmer to be entitled to a subsidy. Clark Phipps legal group for the Syngenta corn litigation is seeking as many farmers as possible. What we want is to obtain their actual grain yields from crop insurance reports for the last 5 years. Crop insurance reports have to be filed with accuracy under penalty of perjury, and most crop insurance agents will fill them out from actual grain receipts. Lawsuits are not going to be quick enough to allow corn producers to survive. It takes too long. The most effective method is to lobby the FSA for a correction in their formula. FSA acknowledges that there is a flaw in the method currently, but there's an executive order that stops them from going any further without proof of error, lots of farm data, and outside political pressure. And that's what we're seeking to bring to bear. You, as a grain producer, to sign a contract which will allow us to obtain these grain yields. It permits your crop insurance agent to release 5 years of yields without breaching your confidentiality. And because it's an attorney contract, we're all bound to confidentiality and the attorney-client protection. Our contracts are pro bono. That means we're not charging any fees for getting this information and lobbying the FSA. We're dedicated to protecting our farm clients, and it allows our Syngenta clients to survive until there's a settlement on the Syngenta litigation. So what we're asking is that you would sign a contract and have your crop insurance agent provide us the last 5 years of your crop insurance yield.